Good morning, Chief Justice, Court Presidents, colleagues and honoured guests. As a member of the Supreme Court and Chair of the Court Services Board, it is my pleasure to welcome you all to the Four Courts this morning to join us in formally opening the new legal year. This is our second such ceremony, which was conceived last year when it was decided that there should be an official event in the courts, hosted in partnership by the Judiciary and the Court Service, to mark the occasion that is the first day of the new Michaelmas term. Formally acknowledging the beginning of a new legal year affords us a number of opportunities which time often does not allow for when terms are in full swing and minds are focused on the daily business of the courts. It gives us a reason to gather together and is an opportunity for colleagues old and new to meet. It also encourages us as members of the legal community to reset, to reflect on the past year's achievements and challenges, and perhaps most importantly, to set our intentions for the months ahead, paving the way for a new collective commitment to the fair and efficient administration of justice and the rule of law. This year, we have seen the celebration of 100 years of our court system, and given the significance of that particular occasion and the events which took place to commemorate it, we thought it desirable to mark the opening of the new legal year with a simpler ceremony. It is worth reflecting that 100 years ago, if we were here, we would be standing in a pile of rubble. Happily, things are looking a lot better now. While it was and remains important to mark the fact that our system has endured now for a century, the year of the centennial has given us more than simply cause for celebration. It's given us pause for thought, reminding us of how far we have come, but also of the significant strides we have yet to make. I'm pleased to say that this year has also carried with it a renewed sense of momentum and drive to press on with our efforts to innovate and put in place the systems and infrastructures necessary in order to make our court system one worthy of taking pride of place in a modern democratic state. It is fitting on that note that the Court Service on Friday last launched its Corporate Strategic Plan 2024 to 27, the second phase of its 10-year modernisation plan, which seeks to ensure that the court system is one that is fit for purpose, efficient, and serves the needs of those who use it and support its operation. The plan is ambitious and identifies key strategic priorities for the Court Service in crafting a system which places the court user at its centre and can respond to the demands of a changing Irish society and demography. Indeed, the plan revolves around a number of core commitments rooted in facilitating swift and efficient access to justice insofar as possible. These include that the court system should be easy to navigate and capable of responding to the unique needs of all those who engage with it, particularly as the population of the country continues to grow and become more diverse, that it should be sufficiently IT-enabled for the digital world, and that court processes should, where possible, be streamlined to bring about greater efficiency, which should result in a system which effectively manages court business and is cheaper to access for members of the public. The success of this plan depends, amongst other things, in having the necessary funding in place to enable it to be achieved. I would like to add that the business of the courts cannot be captured by simply examining what takes place at any single level within the structure. Rather, the business of the courts is in fact the sum of all matters that cross the threshold of any courtroom. What comes before a district judge in the most remote part of Ireland on a Monday in October is the same administration of justice as provided for under the Constitution as any case that comes before the Supreme Court. This ceremony today was designed to mark the opening of the courts in every part of the country, and that, of course, includes the District Court, which we know has already been in full session since September. I would now like to invite Mr. Justice Donal O'Donnell, Chief Justice, to deliver this morning's keynote address. Thank you very much.
You shouldn't worry about 2 bottles of water. Mr. Attorney, Presidents of the Courts, good morning. I would like to welcome everyone to this simple but important event marking the opening of the legal year in Ireland on, as has become traditional, the first Monday in October at the commencement of the Michaelmas term. I would particularly like to acknowledge the presence of some distinguished international judicial visitors. Our neighbours and friends, the Right Honourable Dame Siobhan Keegan, Lady Chief Justice of Northern Ireland, and Mr Justice Stephen Fowler, Judge of the High Court of Northern Ireland, the Right Honourable Lord Patrick Hodge, Deputy President of the Supreme Court of the United Kingdom, the Right Honourable Lord Pentland of the Inner House of the Court of Session in Scotland, and the Right Honourable Sir Julian Flo, Chancellor of the High Court of England and Wales. The presence of international judicial visitors is particularly important. Obviously, it emphasises our international links, but perhaps more importantly, it helps us to adopt a certain perspective in examining our legal system, its strengths, weaknesses, achievements and challenges. The legal business of a year can be very demanding and all-consuming, and it's valuable to have an occasion to pull back the camera lens and try to form some overall view of what has been achieved and where we might go. The presence of our distinguished visitors today is not just an opportunity to meet old friends and make some new ones, but it is an opportunity to view developments in the legal system in Ireland within a broader context. I would also like to welcome all the stakeholders in Ireland's justice system who are present today, including representatives of the Department of Justice, representatives of both branches of the legal profession, the Court Service, the Judicial Council, and the forthcoming Judicial Appointments Commission, representatives of NGOs and civil society groups, and in particular, the judges joining us from each court jurisdiction in Ireland. I said that it has become traditional to mark the opening of the legal year on the first Monday in October, and those words, has become traditional, are what I want to speak a little bit about today. The legal system, with its respect for precedent, tends to start with the presumption that if something has been done before to some effect, it should continue to be done. But the truth is that what we regard as tradition sometimes involves radical change, and other times the quiet discarding of practices no longer considered appropriate or effective or just congenial. The real test is whether the practice that is being followed is aligned with function, if it is still connected to the achievement of an objective that is still considered useful. We are on a site here steeped not just in legal history but in Irish history. And if you're visiting the Four Courts for the first time, or indeed if you are one of the many people rushing through it on a daily basis, you might easily miss a recently acquired artefact from a particularly historic period in 1922. It is the propaganda communique issued on the morning of the 28th of June 1922 by Rory O'Connor, the commander of the forces then occupying the Four Courts, issued in response to the commencement of the bombardment that marked the outbreak of the Civil War. Reading that communique gives a sense of the revolutionary fervour of those like Rory O'Connor who were committed to opposing the treaty. And one telling thing is the date on the document, the 20th of June, not of 1922, but in French revolutionary style, the 7th year of the Republic. Now, I do not suggest that anything revolutionary occurred here last year, nor am I suggesting any change to the legal calendar, but there is a sense in which this can be said to be year 2. It is only the second year in 100 years of the Irish court system, and in the 93 years since those courts have been in operation in the Four Courts building, that the ceremony which marks the opening of the legal year actually takes place in the Irish courts themselves. It had indeed become traditional, by which I mean it was the system which we came to, assumed must have been in place forever, and even became attached to, for the opening of the legal year to be marked by 2 religious ceremonies in both St. Michan's churches. This setup over time came to be accepted as the official opening, but there was a growing unease, which I must say I shared, at the intertwining in Ireland of religion with an important branch of government of a state which was established from the outset more than 100 years ago on republican principles, and which has been in name and reality a republic since 1948. In the years that preceded 1921, there was indeed once a quite elaborate ceremony which took place in this building, known as the Lord Chancellor's Levee, where the Lord Chancellor entered the building preceded by 2 tipstaffs, a mace bearer, and followed by a train bearer and a purse bearer. That ceremony occurred each April at the same time as what was the commencement of the fiscal year. For obvious reasons, there was no ceremony in 1922 or 23, and in 1924, when the new court system was established, there was a short ceremony in June of that year in Dublin Castle, captured on Pathé newsreel footage, involving a procession of newly appointed and, to my eye, slightly embarrassed judges dressed in mourning suits who made their way rather briskly round the castle yard. And in October 1931, when this Four Courts building was reopened, it was proposed that the occasion should be marked by a ceremony, but that was vetoed by the then President of the Executive Council, W.T. Cosgrave, for fear of a possible attack, and the occasion was marked instead by religious ceremonies, private and unofficial, in the two St. Mickens churches. And so the tradition, which many lawyers have encountered in the succeeding years, is really an example of happenstance, which, as many of you will know, is a regular visitor to the legal system. However, it is important, in my view, that if there is to be a ceremony marking an important milestone in the justice system, then it should, in a republic such as this, take place in a public building in circumstances which illustrate the essential equality of every person coming to these courts, irrespective of their beliefs. The message of the last 100 years and more is, in fact, that we have repeatedly made our own traditions, discarded those things that made no sense, adopted others, sometimes for convenience and sometimes for principle. Now, that is how we come here and why we're here today, but perhaps leads to a different question as to why have an opening ceremony at all. As I mentioned already, this provides a moment of reflection and consideration. It will also, I hope, in future, permit contributions from other actors in the justice system, such as ministers, the Attorney General, members of the practicing legal profession, other members of the judiciary, and other NGOs active within the courts and justice system, and provide an opportunity for exchanges. We do not, after all, have many opportunities to do so. As I said, some things change, but some things should remain the same. And one thing that is constant is that judges do not participate in public controversy. That is emphasised in the Bangalore Principles, for example. A central feature of the administration of justice is that the public are entitled to expect a determination made on the merits, factual and legal, by a decision maker without fear or favour and solely by reference to the facts and the law. It is not that people without opinions are appointed judges. Rather, it is that all judges must set aside their fears, their affections and their general opinions and refrain from public comment. And that public reticence in and of itself is an important demonstration of that commitment to impartiality. But that reticence must be respected for what it is. That is much more difficult when we recognise that today's world is one in which communication, both in mainstream media and on social media, is prevalent and indeed pervasive. Most businesses and voluntary organisations and politicians, whether within or outside government, have and rely heavily on communication and media relations advisors. But it's no part of the judicial function to try and manage public reaction in advance of a case or to try to influence public reaction or reception afterwards. However, there are some occasions when it's appropriate for those in leadership positions within the judiciary to make public comment, but even then, it is expected that those occasions should be limited and the expression of views should be measured. At the same time, the way in which the media industry has developed, both at a national and local level, the increasing influence of social media, might lead a regular media consumer to have noticed that the routine day-to-day reporting of court cases, which used to be the staple diet of newspapers and other media, has significantly decreased. And this matters because research in our neighbouring and comparable jurisdictions shows that the more experience and knowledge the public has of the legal system, the greater their confidence in it. Constructive criticism is always welcome, but there is also a corresponding obligation on those who would comment on or criticise the court system based on generalisations to recognise the limitations of the information available, the significant constraints that are upon the courts in general and individual judges in particular. And that's particularly important in today's world, having regard to the role which courts are required to play in societies which are rapidly changing. Recent studies on constitutionalism illustrate the fact that there is nothing inevitable about this form of government in which a system of checks and balances provides for a limitation on the legislative and executive powers by courts. however familiar and essential it may appear to us. And it must be recognised that this system is now under challenge at a level we have not witnessed before, and much of that challenge is directed towards courts, whether at a national or supranational level. That criticism or challenge is in truth existential, and while some elements of it are a refined intellectual analysis, at another level it is more visceral, which is multiplied and amplified and made more dangerous by a number of factors which I have just described. That is to say, a lack of comprehensive, accurate information about courts, a tendency to extrapolate from isolated or extreme instances, and a capacity for criticism to be amplified exponentially by social media and widely shared, particularly with those who have no immediate or direct experience of courts. The entire court system, in providing a form of completely independent adjudication by reference solely to the factual and legal merits, is a key element in maintaining not just order in society, but also confidence in it. The legal system is not simply a service provided by the state. It is an essential element of the state that has a critical role to play in maintaining both the checks and balances of the system and the confidence of the citizens in it. And that is why events like this are not only celebrations. They are also a reminder that we all have a role to play in seeking to improve the court system and, where appropriate, defending it and explaining it. Some of the more significant occasions which took place earlier this year included events organised by a dedicated centenary committee to celebrate and commemorate 100 years of the court system. The objective of those events was not simply to celebrate or commemorate, but to consider the past century and to look forward to the future. On the 12th of April last, there was a very successful conference organised by the Judiciary, the Court Service in Dublin Castle, in conjunction with Dr. Niamh Howlin of UCD, on the Courts of Justice Act 1924 and the surrounding legal and historical landscape. Those papers will be gathered in a book, A Century of Courts, due to be published in November of this year. At the risk of oversimplification, it is worth highlighting from the discussions at that conference the real sense of radicalism of change that was instituted in 1924. But what was once radical quickly became established, and little changed in the succeeding years, which in part reflected a state that had very limited resources and a society which was not so much stable as sometimes stagnant. In contrast, the pace of change, particularly in the last 20 or so years, has been extraordinary and dramatic. The population has increased significantly, become more diverse, law is becoming more elaborate and multi-layered, and litigation is correspondingly expanding, complex and demanding. And it's fair to say that even if these changes were not occurring at their current pace, there would be significant challenges in seeking to administer justice in a system that was devised 100 years ago and in a network of courthouses and auxiliary offices much like this one, which long predated the establishment of the system in 1924. Indeed, the dramatic changes in society, the law and the nature of litigation in recent years increases those challenges and makes it urgent that we take this opportunity to examine our system with fresh eyes and perhaps adopt some of the radical spirit of a century ago. In May of this year, we held an event in the Round Hall to commemorate the 100th anniversary of the coming into force of the Courts of Justice Act 1924. Later that day, President Higgins hosted a memorable reception for visitors and others at Áras an Uachtaráin, where he spoke about the significance of the court system and said, "One may well ask if there is in any aspect of our republic more essential to its effectiveness and continuity than the independence of our nation's courts and their ability to uphold the rule of law. It is, after all, our judiciary that has an enormous responsibility in being part of a system that seeks to ensure not only that order is based on a legitimate and democratically sourced dissent is maintained in our nation, but also that the struggles in which the citizens of our country engage with each other, whether over law, ideas, politics or social values, are resolved reasonably and fairly." And as we in the Supreme Court say in some of our best judgments, I agree. But discharging that important role comes at a price. Many of you will have heard the acronym JPWG, and indeed some of you are significant contributors to it. But it is worth recalling on this occasion of reflection that the situation that led the government to agree to the establishment of a judicial planning working group to assess on a scientific and evidential basis the need for additional judges, both now and into the future. The simple fact is that the approach to judicial numbers and indeed to facilities and other supporting infrastructure had changed little in the preceding 100 years, and the necessary frugality of the early years of the state had become ingrained in the state's approach to resourcing the court system and indeed the justice system more generally. Ever since the EU Justice Scoreboard was first published in 2013, Ireland has had the dubious distinction of being consistently at the bottom of an EU member state league table in terms of number of judges per capita. Ireland also has the lowest number of judges in the 44 Council of Europe member states. And the final component to this perfect storm is that the court system was particularly affected by the economies that were forced on this country as a result of the financial crisis. And IT, which is a key driver in modernisation, was required to be the area within the court system where savings were made by simply not reinvesting in the system as required, so that until very recently, some of the court operating systems in operation dated back almost 20 years. By way of example, IT networks in courts across the country are at or over capacity in most locations, which can result in unstable conditions and disruptions. In this four courts complex, which is now required to hold over 50 judges, in addition to close to 20 in other buildings in the complex, with a vastly increasing workload and requirement for ancillary support staff, the fibre cabling is between 20 and 25 years old and incapable of facilitating the high data speeds needed for modern-day business activities. The Court Service is embarking upon a major network upgrade project later this year as part of its modernisation programme, and which is well underway, in order to revamp networks across the country. But the large technical debt caused by an extended period of underinvestment and the age profile of many courthouses means that significant and consistent investment will be needed over the next decade to provide the physical infrastructure and modern digital services that an efficient court system requires, and perhaps most obviously in this historic building itself. The JPWG had commissioned a report from the OECD which estimated the shortfall in judges in Ireland as between 60 and 108 judges. And the scale of that shortfall can be illustrated by the fact that this was estimated by reference to a system where the then existing judicial numbers were 160, and the Supreme Court complement of 9 should be subtracted from that total, since the successful reform of the appellate structure and jurisdiction of the superior courts in 2014 meant that it was considered unnecessary to review the numbers of judges in the Supreme Court for the purposes of the Judicial Planning Working Group. A shortfall of that nature converts directly into avoidable delay and contributes to a chain reaction where delay increases exponentially. Delay is a constant threat in any legal system because a speedy and efficient system should be a central value in the administration of justice. The JPWG report recommended the appointment of 44 judges to the District, Circuit, High Court and Court of Appeal by the end of this year, 2024, that is 2024. These were to be appointed in 2 phases, the first phase of 24 and the subsequent phase of 20, subject to a satisfactory review. I'm pleased to say that the report was accepted by the Government and the first phase of appointments has now been completed. The implementation of the recommendations of the JPWG has been a learning curve for all concerned, but it has had to be done in flight, as it were, while the court system was still operating. In order to measure the effect of additional judges, it is necessary to gather accurate and, insofar as possible, real-time data. However, that in turn involved constructing an entire system to collect and analyse the data on the disposal of work at each level of the court system and indeed in each courtroom. A second thing that emerged from the process is that there is a direct correlation between judicial numbers and throughput. But judicial numbers are only one pinch point in what is an extended pipeline, all parts of which must function properly if the work is to flow through the system to achieve maximum efficiency. Take the criminal justice system as an example. In order to deal with an increased number of cases, it's necessary that there be an adequate supply of counsel to prosecute them, solicitors to instruct counsel, staff from the Office of the DPP to supervise prosecutions, Gardaí available to give evidence, probation services in some cases, court service staff, and ultimately prison spaces to accommodate persons if they are sentenced at the end of that process. So there is, in this regard, a need for a system-wide analysis. Having said that, it has been possible to analyse data which has been collected in respect of the first phase of additional judges and compare for the first time output in Q1 2023 with Q1 2024. And the simple takeaway is that, as I say, there is a direct correlation between increased judicial numbers and increased output of work. Resources do lead to results. To take just some examples which are, I think, representative of the impact of additional judicial numbers, the district court saw the most protracted process of adding to their judicial numbers, but nevertheless resulted in an 8% increase in the number of family law cases resolved and a decrease in summonses awaiting scheduling by 83%. In the circuit court, family law waiting times were reduced, court sittings were increased by 36%, representing 457 additional sittings. In the Central Criminal Court, the number of resolved cases increased by 8%, waiting times for priority cases dropped by 18%, and defendants on bail saw a 40% decrease in waiting time. If there is a clear appetite for improving these figures further still, which, in my view, there absolutely still should be, then the emerging message is clear, that there is a measurable connection between resources and output. A further consequence of the JPWG process has been the necessity to establish implementation steering groups, which require a degree of communication and interaction between the judiciary, the court service, the Department of Justice and others, with a view to understanding how to best achieve the full implementation of the report and the benefits which it seeks to accomplish. And that, in and of itself, is a beneficial process. The independence of the judiciary does not have to mean the isolation of the judiciary, and exchanges on issues in relation to the functioning of the justice system are valuable for everyone concerned. There is an openness to change within the justice system, just as there was a century ago, but for change which, like the establishment of the Court of Appeal in 2014 or the creation of the JPWG, is firmly based on research and expert analysis, and which can be shown to achieve positive results. Some areas of change are initiated by the government, and others come from within the court system itself. One thing we have become much more conscious of is the emphasis on delivery of judgments. It's widely acknowledged that litigation has become increasingly more complex, involving complicated issues of law rather than simple issues of fact, and the expectation of the nature and quality of judgments has increased. Coupled with that, we have inherited a system that prioritised the listing of cases for hearing because, by tradition, a large proportion of cases, particularly those in the personal injuries list, tended to settle on the day of action. Accordingly, it became commonplace to list many more cases for hearing so that as many of cases as possible could be processed through the system. How a number of things have changed, which mean that there are many more ways in which cases can be settled and resolved without recourse to the court system, and the number of cases which proceed to hearing now is much higher and often involves legal issues of some complexity and which require considered written judgments. It follows that the parties are not necessarily benefiting from an early hearing date. Rather, the critical date for them is the period between the commencement of the proceedings and their conclusion with the delivery of judgment. Producing a written judgment in the Superior Courts is not easy, and it's remarkable how little is understood about the process, even by those within the system. There is an elementary system provided for in the Court and Court Officers Act 2002 as amended, which provides for the listing by the President of a court of a case 2 months after judgment is reserved, before the judge who reserved judgment. However, that procedure is very poorly adapted in practice, for example, in the case of collegiate courts. In the case of the Court of Appeal and Supreme Court, the point at which a judge has produced a final draft of his or her judgment and circulated it to his or her colleagues may only be halfway through the entire process of debating, discussing, analysing, refining, and sometimes dissenting from that judgment. All of this is a necessary part of the process of an appellate court, particularly one which is tasked with deciding points of law of general public importance, the outcome of which is likely to control or at least influence many other legal issues beyond the particular dispute in question. My colleagues in the Supreme Court and I have recently adopted a protocol which seeks to explain the process of producing a judgment in a collegiate court, set the average length of time anticipated, and the steps that will be taken when that time is exceeded. The protocol also provides for the listing of cases in which a judgment is outstanding individually before the presiding judge of the panel that reserved judgment, and in a general list before the Chief Justice in order to communicate the progress of the judgment process. This protocol will be published on the Supreme Court website and the Court of Appeal and High Court are also in the process of adopting similar protocols adapted to the particular circumstances of each of those courts. Some other changes occur externally. This year has seen the promulgation of the Judicial Appointments Commission Act after an Article 26 reference by the President to the Supreme Court, and that Act has had a very protracted gestation. But I'm pleased to say the Minister has recently announced the appointment of 4 lay members of the Commission. There are a significant number of steps that need to be taken by the Commission, but it is, in my view, to be welcomed that for the first time the Commission will be required by statute to provide a maximum of 3 suitable candidates for the Government for appointment, and that selection must be made on merit. There has been considerable debate on the structure of a Commission, and I have contributed to that myself on a number of occasions. But the Commission is now about to be established, and I am firmly of the view that confidence in the judiciary commences with confidence in the appointment process. And I look forward to working with both the lay members and the judicial members of the Commission in that task. In doing so, I must also pay tribute to the work of the members of the Judicial Appointments Advisory Board, who carried out their task, in my experience, very carefully and conscientiously. There is an overall sense, particularly in today's climate, that requests for additional funding by agencies should be heavily discounted or even completely ignored. But I think if we were to look at this in the context of the court system, coldly and dispassionately, 2 things are clear. First, there has been a century of persistent and consistent underinvestment in the court system, not only in judicial numbers, as I have outlined, but also in the ancillary staff required in order to support the operation of an efficient court system, and in the type of physical infrastructure and IT facilities that would be regarded as standard in any modern business. And secondly, there is a causal connection between investment in the court system and beneficial outcomes in terms of reducing waiting times, delays, and increasing efficiencies and the quality of decision-making for all court users, and incidentally, reducing the stresses on judges and court staff in the system. The scale of investment in the system, and therefore the scale by which we still fall short, can be illustrated by a quick rule of thumb calculation, by which it's possible to estimate that the budget of the court service and the salaries and pensions of judges from the Central Fund would, by my estimation, keep the health service funded for less than a week and the education system approximately a week or so. It goes without saying that those sectors face their own unique demands and costs, and I'm not for a moment suggesting that they are not vital state services. But it is a legitimate question to ask whether this comparison is not an instructive reflection of the relative importance, is or ought to be a reflection of the relative importance of the court system in the state, in particular having regard to its essential function in the operation of the state, which I have discussed today. And on the positive side, that calculation shows that an investment that would go perhaps almost unnoticed in other sectors by the state could have a really significant benefit and even transformative impact on the legal system. We have, I think, at the moment, a generational opportunity to address this, to stand back and take a fresh look at the type of model of justice system that we wish to have, one that provides speedy access to justice and fair decisions to all litigants who engage with it, one that contains the best of the system we have inherited, but is well adapted to today's world, a justice system model that we can take pride in and will endure in the future and perform its function in supporting the type of rights-based democracy of checks and balances that we as a people deliberately chose a century ago and ever since, and which we should value, if anything, even more today. Coming back to where I started, it is important to address issues like these on an occasion such as this, but they are not a matter of one speech by a Chief Justice or anyone else. In truth, it is or should be a matter for everybody who is here, for everyone who has an interest in the administration of justice. If it is true to say that the court system has been grossly under-resourced for decades and requires a step change in the approach to its funding, and that increases in funding result in measurable improvements, then that is something which should be said not just by judges whose public utterances must be limited and measured, it should be said by everybody concerned in the justice system. It may not be year 2, but there is much to do, and it is work for all of us. Thank you.
Thank you very much for that, Chief Justice. It's now my pleasure to wrap up year 2 of this formal opening of the legal year. And in doing so, I would like to invite everybody here to take a copy, which is a complimentary copy of the special printed edition of the Irish Judicial Studies Journal. You'll find it on your way out just by the registration desk. My other pleasurable task is to invite you all to refreshments in the King's Inns, where we can renew our acquaintances, continue our discussions, and hopefully have a nice cup of tea and a sausage roll. Thank you all very much for being here.